of the chicken and the egg. There was a man, he was a very clever man, and he earned a fine living from his farm. He raised his chickens, and he sorted all their eggs, and he never did nobody any harm. But then his neighbors, well, they weren't very neighborly, made laws that made it harder to sell what he had grown. So Manitoba, clever fella, headed down to his cellar, made a version of their laws of his own. Then he packed his notes and robes, took his truck out on the road, asked the judges on the court to opine if his law could validly be legislated. When he lost, he said it suited him fine. Man, oh Manitoba, he'll be the one left standing when it's over. Man, oh Manitoba, in the battle of the chicken and the egg.
Welcome back, everyone. This is Howie Kislowitz with another screencast for constitutional law. Today, our topic for discussion is the trade and commerce power and what it has to say about who gets to regulate intraprovincial trade, interprovincial trade, and international trade. As we'll see, the answer to that question is usually pretty easy, but figuring out whether legislation is about intraprovincial or interprovincial trade can sometimes be quite tricky, and I'll suggest to you a little bit unpredictable. So first, let's get the discussion going. If we're looking at a statute that regulates interprovincial trade, then we might start thinking ahead to our pith and substance analysis and our classification analysis at what are the competing heads of power. And you can bet that the dispute here is going to be on one side, on the federal side, the trade and commerce power, and on the provincial side, the power over property and civil rights. Because what we're talking about here is the regulation of business. And we know the regulation of business includes the regulation of contracts, which is a matter of property and civil rights. But on the other hand, what meaning can we make of the trade and commerce power? We know from the old case that we learned way back at the beginning of the semester, the Citizens Insurance case, that the trade and commerce power does give the federal parliament power over interprovincial and international trade. And this stands to reason because we know provinces' jurisdictions are territorially limited to that particular province. So as soon as something starts moving across provinces or leaving the country, we would expect that to be federal jurisdiction. But what this means is that provinces do have control over intra-provincial trade, things that transactions that occur wholly within the province, right? We know that from Parsons as well, that the reason that Ontario had jurisdiction over insurance was because everything happened within the province of Ontario. What that means is for any particular product, there might not be a single legislature in control of its regulation, right? If a product starts off local, but the company grows and starts attracting customers in other provinces, well, then they might have to start dealing with regulators at multiple levels, right? And they might have to deal with a provincial regulator and a federal regulator. So that creates some challenges for businesses, but we might also think about why this creates challenges in the law. When we're trying to figure out whether legislation is aimed at intra or interprovincial trade, sometimes we're drawing some pretty tricky lines. And the reason for this is one of the ideas behind setting up a single country was in Canada was to create a single economic market. And what happens in one part of the country will have ramifications on another part of the country. So if there's a grain surplus in Alberta, which has the effect of lowering the price of grain in Alberta, you can bet that there's going to be an impact on the price of grain in Manitoba, even if that grain is bought and sold in Manitoba. So when we have laws about that, how do we figure out whether we're talking about a law that's aimed at intraprovincial or interprovincial trade? And what we see, I think, in this area of the law, more so than in others, is an acute focus on the purpose of the law. Because once we start getting into the effects, because everything is so interconnected, we can almost always find an effect on if it's a federal statute, then we can find an effect on intra-provincial trade. But if it's a provincial statute, we might find an effect on interprovincial trade. So what courts seem to focus primarily on is the intention of the legislature in passing the particular law. So let's talk about some cases that might illustrate how this analysis has borne out. This is one of my favorite cases to talk about. It's called the Manitoba Egg Reference, also known as AG Manitoba and Manitoba Egg and Poultry. And it's situated in a period that is sometimes known as the Chicken and Egg Wars. And it's about chickens and eggs going across provincial borders. So we might think about this as a case about poultry in motion. So what was happening? Well, in Ontario at the relevant time, there was a surplus of eggs. And in Quebec, there was a surplus of chickens. And what happened was the producers of chickens in Ontario and eggs in Quebec were worried that the surplus product from the other province was going to flood their market. So the chickens from Quebec would fly into Ontario and the eggs from Ontario would roll into Quebec. And that would cut into the profit margins of the egg producers in Quebec and the chicken producers in Ontario. So both the chicken producers in Ontario and the egg producers in Quebec, they went to their respective legislatures and they asked for some regulation to protect their businesses. And what they asked for were what we call agricultural products marketing boards. And it's a common tool across the country. Some people are in favor, some people are opposed. But what's important to know for this particular sequence was those marketing boards were setting minimum prices for the agricultural products in the particular jurisdictions, but they were going beyond just setting those minimum prices. They were making decisions and having rules that favored local producers. So anyone else trying to send agricultural products into that province from another province was facing a barrier to accessing the market. Now, this was a problem in both Quebec and Ontario, as you might imagine, but the people who were hit the hardest were the producers in other provinces altogether, because they were getting, if you were a chicken and egg producer in Manitoba, for example, you were getting dinged in both provinces. So Manitoba does something that's pretty clever. I'm not sure it would work today, and I think it's a strategy that can only be described as Manitoba-Velian. So what they end up doing is they pass an order in council that essentially duplicates the legislation in Quebec, and immediately they refer that draft legislation to the Manitoba Court of Appeal as in a reference case. And the legislation at issue gives the proposed board control over eggs sold in Manitoba, including eggs produced in other provinces. So what they were doing was they were putting this legislation to the constitutional test, and they were hoping they would lose, right? Normally, when a government refers a question to a court, they're hoping that the answer is that this legislation is constitutional. But Manitoba was actually hoping for a precedent that established that this legislation was unconstitutional to pressure Quebec and Ontario to abandon their protective legislation. So what we see from the Supreme Court is we get some dissatisfaction with this technique because there wasn't a lot of evidence, because Manitoba has no interest in defending this legislation. Quebec and Ontario's attorneys general participate, but only as interveners, which means that they can't enter any evidence. And so there was some objection that the factual record was very sparse and this was too abstract. But ultimately, the majority of the Supreme Court says that this is an act that aims to regulate interprovincial trade, making it ultra vires. And I emphasize here the aim part of this phrase, that they were really looking at what was the purpose of this act. Its intention was to regulate importation. Justice Laskin emphasizes that, of course, a province can still subject all the products sold in that province to particular standards like safety or grading, right? So like grade A or grade B meat, and the province can set the standards of what qualifies as those things. And that can apply to imported as well as locally made goods. That would be valid legislation from the province based on its property and civil rights power. But it cannot directly go out and regulate importation. So we might ask, on the basis of this holding, what the vision of federalism implied is here. And we also might ask what the limits of the reference procedure are, whether the use of the reference in this particular context shows that it is subject perhaps to some abuses, and it keeps out some evidence that might have been useful in the particular case. I want to talk about a couple of cases I didn't ask you to read just to illustrate how difficult the line drawing can be. There's a case called the Queen and Klassen, and it relates to grain elevators. Mr. Klassen owns an elevator, and at the time, he would have been subject to federal legislation that required him to comply with certain requirements, with certain technical requirements, reporting requirements, et cetera, just because he had a grain elevator. And his response was, I don't want to have to do that. He was charged with violating the act because he didn't meet the requirements. He said, I shouldn't be bound by that act because it's a federal act. And the grain that I'm selling was all grown in Manitoba, and it's all being sold in Manitoba. It's never leaving the province. So why should we be subject to federal legislation? And what we get is some interesting reasoning from the Manitoba Court of Appeal. Chief Justice Adamson said that these requirements, even though they did affect intraprovincial trade, and this was clearly an intraprovincial transaction, he says that the requirements were necessarily incidental to control the export of grain, right? The use of grain elevators was key in getting grain from the farmers in Canada to other provinces or other countries. And so it was necessary in order to have a system that worked that all grain elevators be subject to these requirements, even if the grain was grown in the province and sold in the same province. So this language should be familiar, this idea of necessarily incidental, the ancillary powers test that we've talked about earlier. The origins of that idea was really in this interprovincial trade jurisprudence. The key here is looking at Chief Justice Adamson's reasoning is that the purpose of the federal act was aimed at the regulation of exportation of grain from a province. And what made it the statute valid was that intention to regulate export, and the fact that it also had an effect on intra-provincial trade did not invalidate the statute. We get a bit more reasoning from Justice Trichler, who concurs with Chief Justice Adamson, who says that yes, this affects property and civil rights, but it's really ancillary to the control of exports. So very similar reasoning. He adds that the goal of the scheme is really to maintain equity between producers, which is a valid goal in his view. And he notes that just because of the way grain elevators worked, you don't always know whose grain ends up where. And any producer's grain might end up exported somewhere down the line, right? That there might be middlemen purchasers who buy from the grain elevator, deliver to a different grain elevator. Ultimately, the grain ends up in another country, another jurisdiction. But we don't know whose grain it is because it's all been intermingled in the grain elevators. One last case to talk about, that is a case called Dominion Stores. This was a case about labeling of apples. So what happens is Dominion Stores sells apples under the label extra fancy, which, who doesn't want an extra fancy apple? But the problem was the federal legislation required, if a store wanted to use the label extra fancy, it wasn't obligatory, but if it used the extra fancy, it had to meet certain qualifications. And these apples were bruised, and so they didn't meet the extra fancy labeling. So the question in this case, that was a federal statute. The question was this labeling requirement, or this set of rules around labeling, was that valid federal law? Because in this case, as in Klassen, the product was grown and sold and consumed all in one province, here in this case in Ontario. And in this case, Justice Esty holds that this labeling requirement wasn't sufficiently integrated into the federal scheme. So it wasn't as necessary to the control of export or interprovincial trade to have these labeling requirements. So therefore, that aspect of the legislation was invalid and struck down. So Justice Laskin disagrees. He ends up dissenting, but ultimately the Supreme Court holds that this was invalid legislation. Why do I put these two cases in front of you? In part because for me, it's a little bit difficult to really separate them on their facts, and it's hard to reconcile the results. So I think the overall pattern that we see in these cases are A, a focus on the purpose of the legislation, and B, a little bit of unpredictability when it comes to figuring out whether the law will be held to be valid or invalid. So for your purposes going forward, just focus on the purpose and ask yourself, is this a law that's about intra-provincial trade, or is it about inter-provincial trade? The effects on the other part, right? The effects on the other level of government's jurisdiction will be less important, I think, than the intention of the legislature that enacted it. And that intention can be proven in multiple ways, as we've seen before. It might be in the act itself, or there might be external evidence that goes to illustrating the purpose of the legislation. Okay, one last topic for discussion, and that has to do with natural resources. I want to tell you a little bit of the background to an amendment to the 1867 Act, Section 92A. We get this new addition to the 1867 Act following the 1970s oil crisis. Now, we talked a little bit about this event when we talked about the anti-inflation reference. And what happened was the producers of oil in the Middle East, that oil cartel raised prices significantly. And that put the federal government in a dilemma. What do? Do we raise the price of Canadian oil to match the price that's being asked for this imported oil, so that at least oil producers will be able to sell their product in a way that ends up contributing to the tax revenue of the federal parliament, and then that maybe can be redistributed? Or do we put in price controls in order to help consumers of oil? So you can see how either solution, there's a winner and loser, right? If we raise prices, then producers of oil will be rewarded. If we cap prices, then consumers of oil will be rewarded, but each at the expense of the other. So the feds are kind of trapped in this contradictory situation. Do they favor consumers, or do they think about how do they think about equalization and provincial inequalities? What they end up doing is choosing to favor consumers. They enact a series of price controls, and this is largely interpreted as a regional victory for the East. So the Section 92A comes as something of a response to this, but it's also a response to the growing importance of hydroelectric energy, which is produced mainly in the eastern parts of the country. And what 92A does is it starts by reaffirming provincial control over natural resources within provincial boundaries. I mean, this was relatively clear from the property and civil rights power, but lest there be any doubt, 92A spells it out. But the really new thing that it does is it gives provinces jurisdiction to enact rules about the export of natural resources. Now, importantly, these rules are subject to federal paramountcy. But in the absence of federal legislation, provinces can now validly enact laws about the export of natural resources from their boundaries. So this changes the dynamic of how inter and intra-provincial trade are distributed between provinces and the federal parliament, but only with respect to natural resources. That's all I wanted to say for today. I look forward to talking to you again soon.
Manitoba, he'll be the one left standing when it's over. Man, oh Manitoba, in the battle of the chicken and the egg, there was a man. He was a very clever man, and he earned a fine living from his farm. He raised a chicken, and he sorted all their eggs, and he never did nobody any harm. But then his neighbors, well, they weren't very neighborly, made laws that made it harder to sell what he had grown. So Manitoba, clever fella, headed down to his cellar, made a version of their laws of his own. Then he packed his notes and robes, took his truck out on the road, asked the judges on the court to opine if his law could validly be legislated. When he lost, he said it suited him fine. Man, oh Manitoba, he'll be the one left standing when it's over. Man, oh Manitoba, in the battle of the chicken and the egg.